Hello, everybody. I'm Seth Weissman, and welcome to another episode of Safe Real Estate. Today, I want to continue the discussion we've been having about mid-year changes to the GAR forms. And one of the other important changes we made was to the section of the contract dealing with the broker's liability and limiting that liability. Specifically, we added language saying that a listing broker shall not be liable for providing false information to the buyer, provided that the listing broker did not know that the information was false and discloses the source of the information that the listing broker received. So let's say, for example, that the property being sold is an estate sale and the seller doesn't know whether the property is on public sewer or is on septic. The seller says to the listing broker, please find out, this is just not something I know. And the listing broker calls the Department of Public Health and is told that the property is actually on sewer, when that later turns out to be incorrect information. In that case, so long as the listing broker discloses to the buyer something along the lines of, I called the Department of Public Health and they told me that this property was on sewer, if that disclosure is made, the listing broker does not have legal liability so long as they have disclosed the source of the information and did not know that it was in fact incorrect or false. So with that as background, one of the things you should always be doing when you are asked questions is you always should disclose the answer and where you got that answer, because so long as you don't know that the information is false, you are legally protected. And interestingly, you're protected not only under our contract, but you are also protected under the Brokerage Relationships in Real Estate Transactions Act. So it's a double form of protection. I hope you have enjoyed this episode of Safe Real Estate. As always, please continue to tune in. Bye now.